hear me now? Please let me know in the comments. I know there's a couple of comments that say you can't hear me. Hopefully that is now fixed. And I am very sorry about that. Um, so today we will be talking about, oh, thank you so much for letting me know. Thank y'all so much. Today we are going to be breaking down some new immigration news and updates and talking about what it means for you in your immigration journey, what it means for a family member in their immigration journey. And one of these topics I'm actually going to be doing a more in-depth video on for Tuesday. So stay tuned for that. But let's jump right in. Most of you already know me, but if you're new here, I am U.S. immigration attorney Lillian Chukura, and I help my clients get green cards and citizenship for themselves and their families using the U.S. immigration law system. So, hi, Francisca. Hi there, welcome. Be sure to say hi in the comments and ask me any questions you may have because immigration law can be confusing and stressful, and I'm here to help alleviate the stress. So feel free to ask me questions. If you're watching this on a replay, feel free to ask me questions as well. I do go back and respond to my comments, okay? So let's start with the most recent thing that happened and probably the one thing that's been in the news. Most of the time, immigration changes do not show up in the news. However, this was a recent executive action by the current president. So we have to talk about it, what it means, because it does have significant impact on people's ability to apply for asylum. So basically, with the new executive order, it breaks down this way. If the people entering the border exceeds 2,500, so 2,500, given day, right? So they're looking at a 7-day period. It is more than 2,500 people that are coming in, and this is unauthorized, right? If you have parole, if you have a visa, that's not included. This is for people that are entering without any sort of authorization from the US government, allowing them to come into the US. If the number exceeds 2,500 in a 7-day period, the border closes, meaning no one gets in, right? No one gets processed. There's no asylum. And if you enter, after that, you will be limited on your ability to apply for asylum. Basically, with this executive order, if you are entering the US in that time frame, you are going to be out of luck because you will not be allowed to apply for asylum. There's like really tiny exceptions, but they're extreme circumstances exceptions. So, for example, if you were a victim of severe trafficking and you basically were not in control of your entry into the US, then that is an exception. However, if you are well within your control and entered the US, this new policy will apply to you. Basically, once the 2,500 number is reached, the number needs to come down to 1,500 before it kind of goes back to the normal processing. So it is a very big deal. It is something that's going to affect a lot of people that are entering that may have qualified for asylum, but because of when they enter the US and how they enter the US, they are now out of luck when it comes to asylum, applying for asylum specifically. But let's talk about what you can do. So if you are outside of the US and you're trying to apply for asylum in the US, there's certain steps that you can take and not just cross the border. If you use the CBP1 app, which is basically a way for you to request an appointment with the Border Patrol and for them to screen you to see if you would qualify for asylum, right? If you have a claim for asylum. And if they find that you have a claim for asylum, they can let you into the US so that you can apply for asylum. So even though this is saying if you hit this number, you can't get asylum, However, the CBP One app, you can still use that to schedule an appointment because that is not unauthorized entry. Okay. If you have an appointment scheduled with Border Patrol, it is not considered unauthorized entry. So you really want to make sure that if you are going to do it, or if you know someone that is thinking about doing this, please use the CBP One app so that you are not in a position that you are now out of luck in applying for asylum. Especially most of the people crossing have a basis for asylum. So you want to make sure that you're following that procedure. This is a major blow to asylum processing in the US. However, you know, as much as I give you the issues, I want to also give you a kind of solution, and that's the CBP One app. All right. So the next thing I want to cover is some USCIS policy changes. So the executive order was more of a Border Patrol ICE policy change. Now let's talk about USCIS policy change because that that typically affects most people that are trying to file for family members or citizenship, things like that. So let's cover the two main changes. So the first one is they've had a couple of changes to their policy manual. I'll be doing a more in-depth video on this for Tuesday, but I do want to cover it today as well. So basically, the USCIS officers have a policy manual. This is how they make decisions on cases. This is how they know, what section of the law to apply on which case. They're not in a vacuum making these decisions for themselves. There's a procedure that they're supposed to follow. There's a policy, there's a manual that they're supposed to follow. And when changes are made to this manual, they have to let us know that they made those changes. So the first one is about the people that have an I-730. So this is for someone that has asylum or refugee status, and they want to file for their family, so their spouse, their children, to also come into the US in asylum status. This used to be handled by the Asylum Vetting Center because, again, it's under asylum. So it's someone that has asylum filing for their family to also get asylum under them. So their family outside of the US to get asylum under them. And this is usually at the Asylum Vetting Center, but this is going to be changing. So they're going to be moving those cases from the Asylum Vetting Center to the International Operations Division. This is, in my opinion, this is a good thing because the Asylum Vetting Center has now been given more work than they used to have. So the I-730s are taking way more time than they used to take because now there's more asylum cases going through the vetting center than there was before. So before it was just the I-730 and very few asylum cases going to the vetting center. Now a lot of the cases that are dismissed in the immigration court so that the person can file with USCIS has to go through the Asylum Vetting Center. And that's a whole lot of cases going through the Asylum Vetting Center. So hopefully this will mean that we're going to get shorter processing times. Hopefully. This means we're going to get shorter processing times at the International Operations Division for the I-730s. Okay. The next change is also a change that may be a good thing, but we will need to wait and see because all of these changes came in May of 2024. So we're going to have to wait and see how it plays out in the long run. Okay, so the next one is the VAWA applications, the I-360. Usually when you file your I-360, it goes to the Nebraska Service Center, and they immediately, without even like checking it and making sure they have everything, send it over to the Vermont Service Center. And that's where the asylum application is actually processed and intaked and made sure that everything that's needed is there. And then they issue the bona fides and everything, right? But here's the problem. Because it's going from the Nebraska Service Center to the Vermont Service Center, you're getting notices saying, oh, we transferred your case. And if you don't know what's going on, that this is just normal, you would think that there's something going on with your case. And this also causes cases to slow down because by the time you take it from one service center to the next, it was taking about like a month just to get the receipt notice for some of our VAWA cases. So hopefully with this change, that's going to also affect the processing times as well. So basically, the Nebraska Service Center is not only going to get the application, they're going to intake the application. They're going to do the full intake processing, including issuing the receipt notice and all of that. So that will, at least in theory, we still have to see how it works out in practice, but in theory, this should lead to at least clients being able to get their receipt notices quicker because their cases are actually being intaked at the Nebraska Service Center, not the Vermont one, which is just going to take more time. All right. And then the last thing, the last policy change is on the family-based petitions. Okay. So typically when you file an I-130 for a family member that's either in the US or outside of the US, if you file an I-130, there's a section on there that asks you if the person will be applying for a green card in the US at a USCIS field office, and they want the field office location. So they want the city and state of that field office. Or if they're going to be applying at an embassy and they would want the city and country of the embassy. Before this policy change, if you did not select USCIS or the embassy, USCIS automatically kept your I-130. Okay, they would not send it to the National Visa Center because they don't know where you want your application to go. So it was a must that you tell them where you want your I-130 sent, either to USCIS or to the National Visa Center. Even if you put that the beneficiary, the person you're filing for, lives outside of the US, if you did not select which, whether they are filing for adjustment of status in the US or for a visa at an embassy, if you did not select one of those, USCIS keeps it. If you put that they're going to be applying for adjustment of status, and you also put an embassy where they will be applying for a visa, USCIS in those situations will also keep it because they don't know what you want. They weren't allowed, the officers were not allowed to guess what you want. So if you don't make it clear, they keep it. Well, that policy has changed. Okay. If they look at the application, the new policy is if they look at your application and they can tell that the beneficiary, the person you're filing for, lives outside of the US, and you did not select whether it's a field office or an embassy, or you selected both a field office and the embassy, they would send the file to the National Visa Center because the beneficiary lives outside of the US. If the beneficiary lives in the US, they will keep the application. Okay. If they choose the wrong thing, right? Let's say the beneficiary is in the US, but they actually will be applying for a visa outside of the US because they did not qualify to apply for adjustment of status in the US. USCIS will still keep those applications unless you tell them specifically you want it to go to the embassy, okay? And in those situations, if they keep it, but you want it to go to the embassy, you must file a form I-824 to basically have them send that file to the National Visa Center. If the case is still pending, right, if they haven't made a final decision on the case, you can still reach out to USCIS and ask them to change where the case is going to be sent. So that's another good thing in this policy manual change is that now they give you the option to contact USCIS and say, hey, by the way, I made a mistake here. I want this to be sent to the National Visa Center. And now it's up to USCIS to then follow through and send it to the National Visa Center once they approve the case. But once they have already approved the case and kept the application, you will need to file an I-824 to basically have it go back to the National Visa Center. If they sent it to the National Visa Center, right? If you wanted it to stay with USCIS, but they sent it to the National Visa Center, all you have to do is go ahead and apply for adjustment of status. Okay, you don't need to file an I-824 for them to bring the file back. No, USCIS will take care of that. They just want to know that you're applying for that adjustment of status. So that is why I always say when you're applying for your I-130, you want to make sure that you are selecting the right things, okay? Because it can really slow down your case, because we've had situations where people come to us after the fact, right? After they already filed an I-130 and the USCIS kept the I-130 and they're not sure what is going on. So we had to file the I-824, and the I-824 has a filing fee and has a processing time. So it can be anywhere. I've had an I-824 take almost a year just for them to send the file to the National Visa Center. So this is a really great change for the policy manual, but it's a great change for the people applying, because if you make this mistake, you can still get to save some time, but it is one of those mistakes that can cost you money and time. So basically the I-130, you want to make sure everything is exactly the way you want it, or it's going to be, it can cause delays for you. Okay. So those are the updates. There was not big shifts, but these little shifts really do make a difference, because you want to make sure that you are following what is going on and how that can possibly affect your case. All right. So I see some questions in the comments, so I'm going to go ahead and answer those. If you have questions and you're joining me, please go ahead and ask me your questions. I am more than happy to respond to them. Okay. All right. So my mom is a green card holder, wants to get my sister a student visa to become a legal resident. How long will it take for her to have a green card? Wants to get my sister of a student visa. Okay, so want to make sure I understand. So I'll answer these two ways because I'm a little confused by the wording. If your sister is in student visa status and your mom is a resident trying to file for her, the question is, has she started the process, and how old is your sister? Because yes, she can file for your sister no matter how old she is, as long as your sister is not married, right? Once she gets married and your mom is still a permanent resident cannot file for their married children. So that's one thing. But as far as how long it will take, it depends on how old they are. So if they're not married, it then depends on how old they are. If they're under the age of 21, it's going to be faster than if they are over the age of 21. So right now, if they're over the age of 21, there's not going to be a visa available until like 7-8 years from now. Okay. And then once the visa is available, then they can apply for adjustment of status. So you can start the I-130 process at any time, but just know, even if the I-130 is approved, if there's no visa available, there's not going to be an application for adjustment of status, even if they're in the US and even if they're invalid status. Okay. So if your sister is in the US with a student visa and under the age of 21, it's going to be a bit faster. But you need to keep an eye. So basically, in these situations, we'd keep an eye on the visa bulletin to see when USCIS is accepting the green card applications for minor children of permanent residents. And once we know that date, we just wait. And then once the priority date reaches, we'll go ahead and apply for the green card. Keep in mind, if they're in the US, they must be in legal status in order for them to adjust their status in the US. And if they have overstayed their status for more than 6 months, they will need a waiver in order to then go outside of the US and come back with an immigrant visa. So it's a lot of moving parts with your question. Yeah, so there's a lot of moving parts. It depends on, you said they're under the age of 21. So it depends on what their status is. Can they get a student visa? Sure, if they meet the requirements of a student visa. But it really comes down to if they're going to be invalid status when that adjustment of status is filed. If they're not invalid status, doesn't matter. They will be out of luck and will need to leave the US to complete the process. And that may require them to get to need a waiver. But what I would recommend is schedule a strategy session, because I have more questions that I can do on here. Because again, this is just general information. I don't have all the details. So all I can give you is general information, okay? All right. So let's go on here. So my daughter filed I-130 for me and it got approved. Yay. I got an RFE for an I-485. They asked for my I-94 and pages of my passport with visas. I only sent a copy of the page of my visa and arrival stamp and I-94. Is it okay? So it depends. So if they specifically said they wanted the biographic page of your passport, typically in my office, I will say this, typically we send that regardless with your application, because we want to make sure that USCIS has everything they need. But sometimes if they only ask for the I-94 and the pages with the visa and the stamps, they're just trying to confirm that you had a legal entry into the US. So that may be okay, but it's really important to look at what they need. Okay, so look at the request for evidence to make sure, if it's just the I-94 and the passport with the visa, then the visa is enough. However, if they specifically mention the biographic page, that probably means you did not send it with your initial application, and they may want that. So just keep an eye out for that. Most of the time, so this is what I will tell people. When they do an RFE, they may want to waive your interview. If they're not sure, they most likely will schedule you for an interview or send you a notice of intent to deny. So they don't go from RFE to denial. They will send you a notice of intent to deny or schedule you for an interview, and you'll still have a chance to send that to them. So keep that in mind. I know it's scary to think that you missed a page, but just know it's not the end. All right. Can a prior marriage of my US citizen spouse affect my green card? She filed her ex-husband years ago. It depends. Right. Can it affect? It depends on when, and if the spouse is still a green card holder. Just know the affidavit of support is still in play. Okay, so when you're filing, you not only have to include you and your spouse and any children or family living with you as part of your household, you will need to include that spouse, that ex-spouse, in the household calculations, unless they have become a US citizen. But if they're still permanent residents, the affidavit of support is still there and they will need to be counted. So yes, it can affect how much money your spouse needs to make in order to sponsor you, depending on the relationship. If there was allegations of marriage fraud, that could come back as well. But if there's no allegations of marriage fraud and it was just the marriage ended, that's fine. But just keep in mind, if the person is still a permanent resident, they are also part of the household when you're calculating income. All right. Next question. My spouse is now working currently. I am an F1 student working on campus and also supporting my spouse. My spouse has not filed taxes before because she has not worked before. Will that be a red flag if USCIS asks us how she is surviving without work? Well, if you are working on campus, depending on how much you're making, are you filing your taxes, right? So if we were in a consultation, that's what I would ask you. Are you filing your taxes together? Because if you're earning income in the US, it's a requirement for you to file a tax return. The rules are different for F1 students, but you can still file a tax return. And if your income, right, you're authorized to work on campus. So if your income is enough to meet the income requirements, that's all USCIS cares about. So if your spouse's income is not enough, you would either need to show that your income from your on-campus job is enough, or you need a joint sponsor. Okay, you need someone else that their income is enough. Her not having taxes filed before is not a red flag, especially if she is young, okay, and if she has never worked in the US, right? It's completely normal. I don't think I filed my first tax return until I think I was in law school. Okay. So I was well over 21 when I filed my first tax return on my own, where I wasn't claimed by a parent. Keep that in mind as well. That may be the reason that she is not filing a tax return, because she's being claimed by a parent. So it is completely normal. It is not a red flag to not have a tax return, but you still need to meet the income requirements for an affidavit of support. All right. Yep. Yeah, it can be explained if she has never worked, but you want to make sure that either you have enough income to meet the affidavit of support requirements, or that you have a joint sponsor to meet the affidavit of support requirements. All right. Okay. Ooh, Instagram. I can't show you how this comment because it's on Instagram. Okay, so it says, "Thank you, counsel. My immigration journey has come to an end. I was approved 4th, I'm guessing June. When do you think I will receive my green card? And second, what update do I need to do with my social security number and other stuff?" First off, first off, congratulations, okay? Because I remember you, right? I remember the questions you were asking me. You were nervous about your interview, and I'm so glad you asked me the questions, and I'm so glad you now are a permanent resident of the US, okay? So the card, typically, once the approval is processed, the card typically comes within a month, typically 2 weeks, but within a month, you should get the card and you'll be fine. If when you filed, so when it comes to the social security number, when you filed your green card application, if you have that application, go back to it. There's a section that asks you if you want the Social Security Administration to issue you a new Social Security card. If you said yes to that question, they will issue you a new one. Okay. If you said yes to that question, they will issue you a new one. But if you said no, you would then have to wait for your card to come in and take that to the Social Security Administration, and they will update your information and issue you a new one. Okay. So it just depends on what you put on your green card application, the I-485. Okay. If you told them to send you a new one, they will send you a new one. But if you did not check that off, if you said no, then you have to wait for your card and then go to your nearest Social Security office, and they will issue you a new one and update it in their system as well. But yeah, congratulations. What is the consequence of filing the I-751 late? So I-751, removal of conditions, you're supposed to file it within 2 years. So before your 2 year card expires, if you miss the 2 year deadline and you are still in a marital relationship with your spouse, you need to file as soon as possible. One, you need to file as soon as possible, and you need to include a reason for why you didn't file within the 2 years. Okay. That's really important. If you do not include the reason, because I've seen people, and this, what I'm about to say happens a lot. I've seen people file an I-90 instead of an I-751, and it's still approved. Okay. So the I-90 will be denied because that's not the right form, but the I-751 can still be approved because you filing the wrong form is a good reason for not filing on time. So it just really comes down to what is the reason. If you file late and you don't have a good reason, or USCIS doesn't like your reason, then they can choose to deny your I-751. And once they deny it, they will revoke it and send you into immigration court proceedings. While you're there, you can have the immigration judge review the I-751 again, and you can refile the I-751 with USCIS. So I haven't had it be like a cases over issue, as long as you have a good enough reason and you actually provide evidence of that reason. Now, you only need to do that if you are filing jointly with your spouse. If you're filing under one of the waivers, so the divorce waiver, the abuse waiver, the extreme cruelty waiver, if you're filing under one of those two, it doesn't matter how late you file. USCIS will still accept it and they will still process it. And you don't need to tell them the reason. Okay. So only when you're filing jointly with your spouse, you need to explain why you're late. But if you are filing based on a waiver, they're not looking at why you're late. They just want you to file as soon as you can. All right. Next question. My child lives in New York. His dad who is a US citizen and lives in Florida. Can he file for his child who is 8 years old? Yes. There's no requirement that he be in the custody of the parent that's filing for them. Okay. So think about it this way. If your child was outside of the US and the father was in the US, right? The father can still file for the child that's outside of the US, even though they're not living with the child. So just think about it that way. All right. Because sometimes it's confusing when you're in the US and you're thinking custody and all of those things. That's not really what they're looking at as far as the green card application is concerned. If we were talking more of like citizenship, if we were talking about, automatically getting citizenship from the parent, then custody matters. But typically with green card application, custody is not as important. Okay. All right. Next question. I have 2 kids under 18 in the US and their mom applied for pending asylum. If I became a citizen, would my kids be citizens? What do I need to do to get them to be citizens? My kids are not living with me though. Okay. So if they are under 18 and they are derivatives for their mother's asylum application, that means they don't really have a status that will take them from where they are right now to citizen. Okay, so you need to get them to a green card. So once you become a citizen, the next step is green card. All right. And once they get their green card, as long as you meet all the requirements for derived citizenship, which does require them for them to be in your physical and legal custody, that's going to be tricky, right? Or they can wait, or you can wait till they turn 18 and they would apply for naturalization. But your first step, because I don't want you to skip that step, the first step is to get them a green card. And then citizenship. So before you get to the citizenship, you just need to get to that green card. Okay. All right. So if you have any other questions, please put them in the comments. I am more than happy to respond. And I do see a question here about P1 and P2 visas. Those are not really my area of expertise. I deal mostly with family based. I love getting families together, making sure that, people are with their family and, all of that. So in general, a P1 visa is more about performance sports, artist visa, right? It has to be unique. You have to be doing something that is different, right? But what I would suggest is reaching out to a business immigration or sports immigration or artists. So there's so many different parts of immigration. I just like my little corner of family immigration because that's just where my heart is. But yeah, you would want to talk to if it's an athlete looking for a P1 or P2 visa, you want to talk to a sports immigration attorney. If it's an artist, you want to look at artist immigration attorney, but some of the times a business immigration attorney will cover all of those as well. All right. Listen, sometimes I can't answer your questions, but I can at least point you in the right direction. All right. So if you have any other questions, feel free to put them in the comments. If not, that's okay too. All right. We do our lives on most Fridays. We talk about U.S. immigration. If it's not obvious, I'm a U.S. immigration attorney, and this is kind of what I do. If you are joining me live and you are getting value out of this, please go ahead and hit the like button wherever you're watching this. I know we're live on YouTube, Facebook, and Instagram. So make sure you are liking this video. And if you have other questions, feel free to put them in the comments of this video. Even when the video ends, you can go back and put your questions in the comments. I will go back and respond to them. I always do. So thank you all so much for joining me. If you would like individual help with your immigration journey, applying for green card, citizenship, for family, for yourself, all of that good stuff, and you want to meet with me to see how I can help you with that process, guide you through the whole thing, you can schedule a strategy session with me by going to my website, lilylegal.com. When you click on contact us, you can actually pick a date and time that works best for you for us to talk. And great question, Kev. I work in all 50 states and I have clients outside of the US as well, because there's some visas that you can apply for from outside of the US without having to be physically in the US. So we represent clients all over the world, basically. So if you would like to schedule that strategy session, you can do it by going to my website, lilylegal.com, or by calling my office at 508-443-1788. Thank you all so much for joining me, and I'll see you next time. Bye.